Thank you all for being here. I'm Dean Reuter, General Counsel and Vice President, Director of Practice Groups of the Federalist Society. Thank you all for being here. Please feel free to squeeze together like you do at Mass or church if there are people that are trying to find seats. It's really my distinct pleasure and honor to welcome our next guest, the Honorable Eugene Scalia, Secretary of the U.S. Department of Labor, which to my mind has a great ring to it, Secretary Eugene Scalia. You can applaud that, please. It's a great deal of fun to wander the halls here and call old friends secretary or judge or whatnot. And that, of course, reminds me of a very brief story that I'll tell, which involves a former Federalist Society colleague, David, who could be exceedingly formal. David would never, ever call someone by their first name without an invitation to do so. He always used a person's formal title. And I watched David interact with one guy in particular, Professor Jim Lindgren, who's of Northwestern, known to many of you here. David would say, Professor Lindgren, could you be on this panel? I'd suggest we think about doing it this way, Professor Lindgren. So Professor Lindgren let this go on for years, decades even, until one day, Professor Lindgren said, David, we've known each other for years. Please, call me Mr. Lindgren. So turning to Secretary Scalia, he has a sterling resume. He's graduated with distinction from the University of Virginia, went on to the University of Chicago Law School, where he graduated cum laude and served as editor of the Law Review. He served as a speechwriter to William Bennett, Secretary of Education during the Reagan administration. From 92 to 93, he served as special assistant to Attorney General Barr, from whom we'll hear more this evening. And this, of course, is not his first tour at the Labor Department. He served as Solicitor of Labor, the department's principal legal officer in the early 2000s. In the interim period from all these high-level government positions, he earned a national reputation as an expert in labor and employment law and in administrative and regulatory law in private practice at Gibson, Dunn & Crutcher, where he also distinguished himself as the go-to lawyer for challenging questionable agency action. Importantly, during those same interim periods, he's been a leader of the Federalist Society. And we're very pleased to have him with us today. Please join me in welcoming Labor Secretary Eugene Scalia.
Thank you, Dean. Thank you all. It's a great pleasure to be at this conference and to have the chance to talk to you all today. The Federalist Society is a deeply important institution to which my family and I feel a strong personal tie. Many of us had the pleasure last night of coming to the dinner now named in honor of my father, Justice Scalia. He was a professor to Lee Otis and David McIntosh, two Federalist Society founders, and was the first faculty advisor to the Chicago Law School chapter. In his years on the court, my father enjoyed few things more than speaking to Federalist Society Law School chapters, teaching his FedSoc separation of powers course over the summer, and of course, coming many times to this conference. He relished the opportunity these events gave to teach, to explain, and above all, perhaps, to argue. He drew strength from the friendships and camaraderie here, which on more than one occasion helped boost his spirits after a disappointing decision or term. Among our fondest memories as a family was the 2011 annual dinner, when the Society recognized my father's 25th anniversary on the court by inviting my 8 brothers and sisters and me to join our parents on stage. My father proudly introduced us and said, 9 children, and not a dullard among them. And my brother Chris, he complained under his breath to us, Daddy always forgets about me. For my part, the first time I ever made public remarks was at a 1986 meeting of the Washington Lawyers Chapter. I was asked to introduce my boss at the time, as Dean mentioned, Education Secretary William Bennett. That's when I had the good fortune to meet 2 young Reagan administration lawyers who had helped start the chapter at Yale and would go on to clerk on the Supreme Court and do other interesting things, Steve Calabresi and Peter Keisler. I joined the Society in law school and about a year later and have been an active member since. That said, I realize that it's not my personal connection to this organization that is the reason for my invitation to speak today. It's because of the position I hold as Secretary of Labor. The subject of this conference is originalism in the Constitution. I head a 15,000-person cabinet department that has important enforcement responsibilities, that issues what we call legislative rules, and houses several adjudicative agencies. Evidently, Gene Meyer thought I should come here and give an accounting. Or perhaps Leonard Leo and Dean Reuter here thought I should address one of the important constitutional decisions involving labor and employment law. There's Lochner, an early application of substantive due process, striking down a regulation of working hours. That era, the Lochner era, ended with the West Coast Hotel v. Parrish, the so-called switch in time that saved 9, involving a minimum wage law. That same year, 1937, the court upheld the constitutionality of the National Labor Relations Act in Jones v. Laughlin Steel, a decision that set the court on its modern-day approach to the Commerce Clause. As for the Labor Department itself, it's been involved in some noteworthy decisions. Who can forget Garcia v. Antonio Metropolitan Transit, where the Supreme Court disclaimed much of its responsibility for policing Congress's use of the Commerce Clause to regulate states. And I know that some in this audience have been heard to complain about yet another decision involving the Labor Department, even though it was a unanimous decision written by the great originalist Eugene Scalia. In this case, Auer v. Robbins, my father presciently recognized the appropriateness of deferring to what I, the Secretary of Labor, say in amicus briefs. Any of these cases would provide rich material for a speech on originalism, but that will have to await some other time. Today, being new to my position, I wanted to talk about some constitutional principles that will guide me as Labor Secretary. I'll conclude with a foundational constitutional principle that is currently embattled, I think, in which lawyers have a special interest in defending. No one's better equipped to do that than members of this group. Article 2 of the Constitution directs the President of the United States to take care that the laws be faithfully executed. The Supreme Court has said that the Take Care Clause embodies the President's most important constitutional duty. It's a duty that I consider myself to hold as well as a principal officer appointed by the President with responsibility for administering and enforcing a range of statutes. Put differently, the President takes care that the laws are faithfully executed in part through the officers he appoints to run the cabinet departments. This means to me that as Secretary of Labor, I have a constitutional responsibility for the agency's enforcement activities under the statutes it administers. This includes the Fair Labor Standards Act, governing minimum wages and overtime, ERISA, concerning pensions and employer-sponsored health plans, OSHA, and the Mine Safety Health Act, and the worker protections that apply to unions under the Landrum-Griffin Act. The department, of course, also enforces the non-discrimination requirements applicable to federal contractors. The enforcement actions we bring under these and other statutes are not merely the responsibility of the capable Labor Department officials we have in the field. They're activities for which I'm accountable as the Secretary and as the official in whose name those cases are brought. And so it's incumbent on me, and by extension, it's incumbent on the heads of the agencies within the department to exercise appropriate oversight over our litigation nationwide. As I review our enforcement activities, one thing I'm interested in as Secretary is the effectiveness of our investigative programs. We should be selecting companies for inspection and investigation based on the likelihood that there will be a prosecutable violation of the laws we administer. Our inspections and investigations should be targeted to that end, and if they are not effectively identifying violations of law, resources should be redeployed to places where significant violations may be more likely found. Inspections and investigations are not ends in themselves, but tools that must be wielded thoughtfully to enforce the laws effectively and efficiently. In taking care that the laws are faithfully executed, I'm also interested in consistency. As I'll discuss in a moment, we should strive to make the law's requirements clear. The Labor Department administers statutes of national application. The regulated public should be subject to a consistent nationwide interpretation of those laws. The interpretation shouldn't vary based on the parties involved or the jurisdiction where the case arises. Consistency in enforcement furthers compliance and respect for the rule of law, and it will be one of my goals as Secretary. Of course, taking care that the laws are faithfully executed includes vigorous enforcement where warranted. I did not shrink from that previously when serving as solicitor, the general counsel at the department, and we will not hesitate to do so while I'm Secretary. In fiscal year 2019, the department's wage hour division recovered more than $320 million in wages owed to workers. That's a record for wage hour. Recently, the department used its so-called hot goods authority, which is a powerful weapon we have, to recover nearly $6 million in back pay for workers and other employees at a company that shut its door without paying its workers. This was a 100% back pay recovery for all the affected workers except the CEO and 2 family members. The department's Office of Federal Contract Compliance Programs, which, as I mentioned, enforces non-discrimination requirements for federal contractors, also obtained record recoveries in 2019, over $40 million. And investigations by the department's Office of Labor Management Standards, which enforces union democracy and financial integrity laws, led to 60 criminal convictions in fiscal year 2019. For OLMS, which works together with the Justice Department, that's 5 convictions a month. A second constitutional principle that will be important to me as Labor Secretary received early expression in a 1926 case involving employment regulation. Connolly versus General Construction involved an Oklahoma statute that required businesses to pay workers, quote, not less than the current rate of per diem wages in the locality where the work is performed, end quote. The statute provided for financial penalties and imprisonment of 3 to 6 months for each violation. The Supreme Court found this criminal prohibition void for vagueness, saying the dividing line between what is lawful and unlawful cannot be left to conjecture. This is generally known today as the principle of fair notice and has been extended to actions of administrative agencies. For example, as many of you know, in the 2012 FCC Fox case, Justice Kennedy wrote that, quote, regulated parties should know what is required of them so they may act accordingly. Precision and guidance are necessary so that those enforcing the law do not act in an arbitrary or discriminatory way. My department has not been immune from criticism in this area. In another 2012 case, Christopher v. Smith-Kline, the court refused to give deference to a Labor Department interpretation of its own regulation that had not been that had been articulated in amicus briefs and not in rulemaking, and which had changed over time. Justice Alito, quoting an opinion by my father, said that deference to the agency's interpretation in this circumstance would seriously undermine the principle that agencies should provide regulated parties fair warning of the conduct a regulation prohibits or requires. In my view, a lot of the criticism we've heard in recent years of Chevron and Auer and other deference doctrines has in part to do with the concern of some that those doctrines as sometimes applied fail to give fair notice. Fair notice and consistent, effective, and efficient execution of the law will be important to me as Secretary, and they are important to President Trump. Last month, the President issued 2 executive orders to implement principles of fair notice and to promote efficient and effective implementation of the law. The first order requires agencies to post all guidance documents online in a searchable format so they can be easily found and read by the public. Guidance documents not included on that website are considered rescinded. Significant new guidance documents go through OMB review and public notice and comment. The second executive order instructs agencies to recognize that guidance documents are non-binding and cannot create an independent basis for enforcement action. Pre-existing statutes and duly authorized regulations must provide the rule of decision in enforcement actions. This doesn't mean that guidance is wrong or bad, by the way, in my view. On the contrary, if they serve to highlight legal requirements that reside elsewhere in a statute or in a regulation, guidance documents help provide fair notice. When I was a practicing lawyer, my clients wanted guidance. What they didn't want, what they rightly objected to, were government edicts labeled as guidance that threatened or coerced them to comply with new legal norms without the protections of notice and comment rulemaking. At the Labor Department, we will continue the compliance assistance programs that are an essential part of how we inform the regulated public of their obligations. President Trump's attention to the proper use of guidance is part of a broader commitment he has demonstrated to eliminating unnecessary regulatory requirements that stifle American innovation and productivity and which burden the economy. A government of limited powers was, of course, central to the framers' original design for our Constitution. In a debate in the House in 1789, for example, James Madison deplored what he called commercial shackles. It is a truth, he said, that, quote, if industry and labor are left to take their own course, they will generally be directed to those objects which are the most productive, and this in a more certain and direct manner than the wisdom of the most enlightened legislature could point to, end quote. In this spirit, President Trump, early in the administration, ordered federal agencies to take 2 regulations off the books for every 1 added. To date, the administration has cut at least 8 regulations for every 1 that's been added. The Council of Economic Advisors estimates that these changes have saved the American economy about $50 billion and will achieve cost savings of $220 billion once fully implemented. At the department, we have taken a number of important deregulatory steps, and we have more in the works. The President's deregulatory efforts, together with other steps, like his 2017 tax cuts, are having their intended effect. Right now, the American people are benefiting from an extraordinary economy. Part of my job as Labor Secretary is to gather and report employment-related data through the Department's Bureau of Labor Statistics. That data shows a job market that few of us have seen in our lifetimes. The national unemployment rate is 3.6%, which is close to the lowest rate in more than 50 years. More than 6.3 million new U.S. jobs have been created since January 2017. Wages are rising. They've been rising at or above 3% for 15 months. They're rising faster than prices, and weekly earnings are rising faster for the lowest paid full-time workers than for the highest paid. The job report we issued in October showed the lowest unemployment rate ever recorded for African Americans. We've also seen the lowest unemployment rates ever recorded, or some of the lowest ever recorded, for Hispanic Americans, Asian Americans, Americans with disabilities, adult women, and Americans who do not have a high school diploma. I recite all this data to you, not just because the major media often downplay or ignore it. I recite it also because it confirms a truth that Ronald Reagan believed to his core and that drives our current president too. The simple best thing for working Americans, including women, minorities, and Americans with disabilities, is a vibrant, growing economy in which businesses compete to attract and retain workers. The current economy helps workers in other, less obvious ways too. When I speak to business people, the concern they now cite most frequently is the tight job market, the challenge they face finding workers. That's a real problem that we need to address to keep the economy growing, and it's one of my principal concerns as labor secretary. But the tight job market is helping workers. Businesses, in addition to raising wages, are investing more in training so they can bring more workers into their company. This is part of the reason that apprenticeships are a high priority for American business, the Labor Department, and the White House. In this tight job market, employers are also taking a closer look at job applicants that in other times they might pass over. As I mentioned, the unemployment rate for Americans with disabilities right now is the lowest ever recorded. Employers are more open to hiring Americans re-entering the workforce from the criminal justice system. And in part, so they can retain and find new workers, businesses are helping tackle a crisis that's afflicting our country. That's opioid abuse, which claims tens of thousands of lives every year and which has terrible radiating impacts on countless American families and communities. Responding to this crisis is a priority to President Trump and the Labor Department, and American businesses want to help. They want to help in part because they recognize it's another means to bring more workers into their workplace. I wanted to mention a final twist we're observing, which is a robust economy in which companies are searching for workers can help sweep away still other unnecessary regulatory barriers. Right now, we're seeing a nationwide movement to reform requirements for occupational licenses in the states. In part, this involves increased state reciprocity. Earlier this year, Governor Ducey of Arizona signed a bill that allows the state's licensing boards to accept out-of-state occupational licenses for new residents. If you're good enough to be a realtor in California, Arizona trusts you to do it there too. And Governor Ducey, I'm pleased to have you join us here today. These state reforms, which have been championed by President Trump, have been bipartisan. Colorado Governor Polis recently vetoed bills to reimpose licensing requirements on sports agents and homeowner association managers. He said the objective was to make sure that licenses protect people from harm, not industry insiders from competition. These are valuable deregulatory initiatives, and they result partly from prior deregulatory efforts undertaken by this president, which have contributed to today's vibrant job market. So for all of these reasons, I urge you to remember this particular moment in our economic history and in federal policymaking. Smart deregulation that frees American business gives an incredible boost also to the American worker. Well, I wanted to conclude this morning by talking about another bedrock constitutional principle, one that's been particularly important to this organization. Last Sunday marked the 100th anniversary of Justice Holmes's famous articulation of the value of free speech in the Abrams case. He said the First Amendment embodies the view that, quote, the ultimate good is better reached by the free trade in ideas. It is, quote, the theory of our Constitution, he said, that the best test of truth is the power of the thought to get itself accepted in the competition of the market. Now, I admit to some doubt that fundamental truths are established in the same manner as the value of pork bellies. But Holmes was right that the free exchange of ideas is at the core of the First Amendment and at the heart of our democratic government. And yet, it is disfavored in some quarters today. That's most apparent at colleges and universities, where conservative speakers have been disinvited, banned, assaulted, and when allowed to speak, accused of harming students merely by expressing ideas that run counter to some students' preconceptions. This intolerance is not isolated to our universities. It's a broad trend, so much so that 2 weeks ago, it drew criticism from former President Obama. I believe that this intolerance and the pressure to suppress ideas that may be unwelcome to some poses a special threat to the practice of law. One of the great traditions of the legal profession is to respect the right to legal representation of those we disagree with, and even to undertake that representation ourselves. John Adams's defense of the British soldiers charged with the Boston Massacre is one of our most important stories about the practice of law. Adams wrote that his defense of those soldiers was, he said, one of the most gallant, generous, manly, and disinterested actions of my life. Adams wasn't our most modest founder. But on this, he was right. It is appropriate, admirable, and necessary for lawyers to take on clients in advanced positions that may offend some observers. In this sense, lawyers have a professional commitment to the free trade in ideas praised by Justice Holmes. They should be among its staunchest defenders and should recognize, too, in Justice Jackson's words, that the freedom to differ is not limited to things that do not matter much. That would be a mere shadow of freedom. And yet, there are growing indications that our most powerful law firms are growing uncomfortable with this commitment. Earlier this week, the Supreme Court heard argument in the challenge to President Trump's cancellation of the DACA program, under which certain young people who entered the country illegally received forbearance from deportation. By my count, approximately 25 large law firms filed amicus briefs opposing the president's action, on top of the 3 large firms representing the plaintiffs. Not a single major firm filed a brief supporting the administration's position. Similarly, at the start of the term, the court heard argument in the Bostock case, presenting the question whether Title VII's prohibition on sex discrimination includes discrimination based on sexual orientation. Around 20 large law firms filed amicus briefs supporting plaintiffs in a broad reading of Title VII. Not a single big firm filed a brief supporting the defendant. As should be very apparent from my preceding remarks, I have no objection to any of these firms providing the representation they did. I should be clear also that nothing I say today should be understood as a criticism of my former law firm, where my friend and mentor Ted Olson argued on behalf of the DACA plaintiffs. He also represented Governor Bush in Bush v. Gore. My concern is not the particular position any individual firm took in any specific case, but the complete absence of any large firm on the other side of either of those cases, and a similar imbalance in other cases involving hot-button issues. Everyone familiar with the practice of law knows that these lopsided representations have nothing to do with the legal merits of the 2 cases, or with the absence of lawyers at large firms who would be interested in representing a client on the other side. There are lawyers at large firms, maybe some in this room, who would have welcomed the chance to file a brief supporting the government's position in the DACA case, for example, or supporting the defendant employer in the Title VII case. One factor preventing that, in these and other cases, I believe, is self-censorship. Our elite law firms are hesitant to let their lawyers get involved in cases that might generate criticism from left of center, or that conflict with views other lawyers in the firm may hold personally. Second, and related, firms fear repercussions from certain well-heeled corporate clients if they take positions disfavored by progressives. And sadly, there's reason for that concern. As many of you know, and all of you should, some years ago, clients of Paul Clement's old law firm, a different firm than where he works now, pressured that firm to end Clement's representation of the House of Representatives in connection with the Defense of Marriage Act. Clement left that firm. In the aftermath of that episode, firms are even more hesitant, I think, to get involved in high-profile, controversial cases taking right-of-center positions. Today, it's difficult for certain clients to obtain representation from our top law firms because the firms fear repercussions for doing so. Fortunately, smaller, boutique litigation firms often step in to provide representation. But it remains troubling that the largest law firms increasingly shrink from their lawyers representing clients on the right-of-center side in controversial cases. John Adams would be concerned by this trend too, I think. And it should trouble the legal profession, particularly lawyers at private firms. The public must be reminded that a firm's representation of a particular client or its presentation of a particular position does not necessarily, obviously, reflect lawyers' personal views or the position of the firm itself. Firms should pride themselves, as they have in the past, on representing people or positions that may be disfavored in some quarters. They should be leading defenders of Holmes' vision of a free trade in ideas and should push back firmly on clients who seek to judge or muscle the firm because of another client the firm represents. It can't be assumed that corporate executives know or will honor and defend the values of the legal profession. That is the role of members of the bar. Firms should explain to clients that no single representation defines the firm. The firm will allow its lawyers to provide pro bono representation to murderers without approving of murder. Its lawyers will represent companies charged with securities violations without approving of defrauding widows and orphans. And its lawyers will represent the little sisters of the poor without, heaven forbid, accepting the teachings of the Catholic Church. Firms should also remind clients that it is this detachment of lawyer from client, of the conduct being defended from the lawyer defending it, that facilitates firms' representation of corporate clients accused of troubling misconduct. Today, a corporation accused of environmental crimes objects to a lawyer at its outside law firm filing a brief in support of the unborn. Tomorrow, why can't someone schooled in today's cancel culture use the same logic to attack the firm for defending that company's environmental depredations? Saying, hey, we're profiting from this work is not going to be a satisfactory answer to many, particularly in a culture that devalues the First Amendment and which has lost sight of the special place and independence of members of the bar. Well, it's been a pleasure to be with you today and over this week. A central reason many of you come is the Federalist Society's commitment to the principle I've been discussing, the free exchange of competing ideas. That's evident from the list of people who've spoken at this conference, as has been observed in the past. if this were an organization dedicating to promoting one single narrow-minded view of the law, you invite the wrong people to come talk. I hope that you enjoy your panels and your debates this week, and that when you return home, you have occasion to promote these First Amendment principles within our profession as a whole. Thank you.
Thank you. That was terrific, Secretary Scalia. We have time for questions. There are microphones in the aisles to take questions. We've only got a few minutes. We are all textualists, so we understand what a question means. Brian in the back.
Yeah, thanks, Dean.
Yeah.
Brian Bishop from the Stephen Hopkins Center for Civil Rights. Secretary Scalia, I'm wondering, you came to my attention with an article in the Harvard Journal of Law and Public Policy that contrasted the success of unionism, especially in the private sector, with the advance of government regulation side came up, the interest in unionism or in the tangential benefits of it consequently diminished. And I'm wondering, now that you have the role of enforcing this body of regulation, so seeing it carefully enforced, is there a way that you may also advance the interests of essentially private relations between employers and employees?
Well, that was just kind of Larview theorizing, you know. Now I'm in the government. Yeah, that was a piece I wrote some time ago, and the basic point was that you could look at the union framework we have as one model for regulating the employment relationship, with another model for regulating that relationship being mandates imposed by the state. And I pointed out that unions' decline in membership seems to have occurred to some extent parallel with increase of direct regulation of the employment relationship. You know, sadly, that idea never got much interest or traction. But am I interested in ways that we can further private employment relationships? I mean, very much so. I think that's at the heart of our mission. I think we should respect those relationships while also recognizing the importance of the legal obligations that we are charged with enforcing. But I couldn't tell you that that article will be a charter for how we approach things. Sorry.
I can dream, can't I?
We'll count that as a follow-up question. Yes, sir.
Cameron Atkinson from Connecticut. Secretary Scalia, how would you address, in the context of increasing free censorship of speech in the public employment context, especially in the light of the Garcetti decision and then Lane v. Franks in 2014, what do you see the scope in terms of how public employers should be operating under the Pickering balancing test, and then how it was narrowed in Franks?
I think we should let you answer that question, because that, with all respect, I'm afraid that involves a degree of nuance and multi-factored test that I didn't come here prepared to answer. I think, look, you're balancing on the one hand the free speech rights that we all have. You know, that's a point in which Justice Holmes has been determined wrong, right? You do have the right to be a policeman and also have free speech at the same time. But it is important at the same time that people who represent institutions in doing so represent those institutions. So those are the competing values. A balance has to be struck, and the Supreme Court seems to continue to be working at that.
Yeah, definitely, but the line gets blurry, obviously. Thank you.
Hi, Secretary. My name is Vishru Chalat. I'm a 3L from Vermont Law School. My quick question for you was about the Chevron deference standard. Both sides of the political spectrum, conservatives and liberals, have used the Chevron deference as a tool to provide more power for the administrative agencies to demonstrate their expertise in a given field. So my question to you is, do you think the Chevron deference standard, particularly step 0, is a affront to originalism? And I'm not trying to imply that it is, but I'm just wondering what your stance on Chevron deference and originalism is. Do you think that expanding the power of the federal government and its expertise through the expertise argument takes away the rights of the states to determine how administrative law should be applied in their own jurisdictions? Thank you.
You know, for the first time in, I think, more than 30 years, I'm actually not a lawyer. And I've got a terrific one, Cato Scalia, here in the front row, my solicitor. That has some real upsides. And one of them is, on questions like that, I can often turn to others for guidance. Hey, Kate, can you come? No, I'm kidding. And more importantly, turn to the Justice Department to lay out what they regard as the proper way to approach this topic until the Supreme Court provides further direction if it decides to do so. And that said, I'll admit, on a personal level, I've just got some fondness for Chevron just because I've got a dad who just loved the thing. At least to his last years. I think there remain arguments to be made for Chevron deference. It certainly, in some contexts, poses serious problems, and I've had cases on both sides of the Chevron issue in the past, and I suppose there'll be cases with my name on them in the years ahead, again, where both sides are presented. So it's best for me not to try to speak for myself in addressing that, except that, like I said, I've not been as great a Chevron critic as some, in part just out of respect for the old man, but in part too, because I think there are some serious considerations on both sides.
Thank you.
Well, Secretary Scalia, thank you so much for being with us today.